We're going to have to get very geeky. I know this is going to cost me lots of views. It doesn't matter. We have to go over this and be very clear. What does it mean to infringe? The right of the people to keep and bear arms shall not be infringed. I really want to talk about this so you understand exactly how to defend the word infringed. It's extremely important for our rights to talk about the word to infringe and what it means. Stay tuned. We're going to get really geeky and go back to the 18th century in 1 minute. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and author of Disarmed, What the Ukraine War Teaches Americans About the Right to Bear Arms. All right, folks, this is not going to be a very long video. It's not a very sexy video, but it's an extremely important video, okay? We've talked about this before, that the United States Supreme Court has not yet defined the word infringed, okay? The text of the Second Amendment, as you know, the operative clause is the right of the people to keep and bear arms shall not be infringed. The right of the people to keep and bear arms is a pre-existing right. It existed before 1791. It existed before the founding of the country. It existed before the Bill of Rights. Okay? That's why it's written the way it is. The right of the people to keep and bear arms shall not be infringed. But we now need to talk about what it means, shall not be infringed. To do that, we have to talk about what the meaning of infringed means. Okay? Because if we don't explain what infringed means, we can't sue and win Second Amendment cases. And for those of you talking to elected officials, or for those of you talking to, your family, or for those of you talking to your community, whatever it is, your gun clubs, it doesn't matter who you're talking about the Second Amendment and what it means to educate them, you got to understand how to define infringe. Now, the Supreme Court has not technically defined expressly so the word infringement or to infringe. It just hasn't. However, we know what the word infringement or to infringe means because all we have to do is look at the exact same dictionaries from the 18th century that the Supreme Court looked at in the Heller case. The Heller case was decided by the Supreme Court in 2008. It dealt with the District of Columbia's ban on handguns and issuing the ruling that says that a ban on handguns was unconstitutional under the Second Amendment. The Supreme Court did the exact same Bruin methodology. It looked at the plain text of the Second Amendment. It defined all the terms. It then went on to say that a ban on handguns violates the text of the Second Amendment. It then went on to look at the history and said that there is no basis for banning, at a minimum, there is no basis for banning weapons or arms that are in common use by Americans for lawful purposes because handguns were in common use by Americans for lawful purposes in 2008. They are protected under the Second Amendment and simply cannot be banned. Okay? With that said, the Supreme Court defined all the words of the Second Amendment except to infringe, but that's okay because we're going to do it for you right here, right now, and it's important that you remember this. It's going to be very easy once you understand what I explain here. It's not going to be that hard, but you're going to be the smartest person in the room when you understand and cite these sources. Okay? There are three. I repeat, there are three sources that define the terms of the text of the Second Amendment. We're not going to get into history here. We don't need to get into history for this. It's about the defining of the words. The right of the people to keep and bear arms shall not be infringed. What do those words mean as a matter of textual definitions? Words have meanings. The meaning of those words are usually found in dictionaries. Because the Second Amendment was adopted in 1791, we go back to the 18th century and try to understand what was the original public understanding of the words of the Second Amendment when it was adopted. What did the people that actually wrote the Second Amendment, that voted for the Second Amendment, that ratified the Second Amendment, that understood the Second Amendment, what did they think they were enacting when they enacted the Bill of Rights, including the Second Amendment in 1791? Well, one of the ways that the Supreme Court has historically done this is gone back and says, well, how were these terms defined in dictionaries at the time of the founding? And there are three key people I want you to know about, because these three key people were the sources of the definitions of the Second Amendment in the Heller case. The first person is Samuel Johnson. We've talked about him before. He was a British lexicographer. A lexicographer is a person who writes dictionaries. Samuel Johnson was based in England, in Great Britain, and he wrote the Dictionary of the English Language that was published in 1773. In In his dictionary from 1773, Samuel Johnson defines to infringe as meaning to hinder or to destroy, to hinder. So any hindrance, right, any restriction or hindrance on the right to keep and bear arms violates the definition of infringement, or I should say constitutes an infringement and violates the text of the Second Amendment according to Samuel Johnson's dictionary in 1773. Now, Samuel Johnson was used by the Supreme Court in Heller to define the word arms. Specifically, in the Heller case, Samuel Johnson's dictionary, the same one we just used to define to infringe, defined arms as weapons of offense or armor of defense. The exact same dictionary that the Supreme Court used to define arms in Heller, if you use that same dictionary to define to infringe, it means to hinder. Samuel Johnson. Okay, I should also note that Samuel Johnson was also used by the Heller Court in 2008 to define to bear, which means, of course, to carry. So here you have Samuel Johnson being used for multiple words, meaning to arms as well as bear in Heller, and of course, his definition of infringe means to hinder. Now, the next important person beyond Samuel Johnson, of course, is Noah Webster. Noah Webster was an American. He wrote the first American English dictionary of the English language in 1828 using definitions and understandings of the words during that founding era. Remember, 1828 is part of the founding period for our purposes when it comes to defining words because James Madison passes away in 1836. So the last conceivable date you could argue is part of the founding period is 1836. But Noah Webster wrote his dictionary in 1828 within that period. Now, Noah Webster was used by the U.S. Supreme Court in Heller to define arms. Again, what did Noah Webster define arms as? He basically defined it in 1828 as the same thing that Samuel Johnson defined arms as, really weapons of offense or armor or defense. So again, Samuel Johnson and Noah Webster defined arms in the Heller case the same way. So Heller relies on Noah Webster to define arms, which to show it's consistent with the Samuel Johnson definition. And the Heller case, the Supreme Court uses Noah Webster's same dictionary from 1828 to define the word to bear, which means to carry. So again, here we have Noah Webster used by the Supreme Court. His dictionary was used to define arms in the Heller case. It's also used to define to bear, which means to carry in the Heller case. So again, how does Noah Webster's exact same dictionary in the Supreme Court in Heller used, how does he define infringement or to infringe? And just like Samuel Johnson, he defines it as to destroy or to hinder. So again, whether you look at Samuel Johnson or Noah Webster, to hinder a right constitutes to infringe or an infringement. As in the right of the people to keep and bear arms shall not be infringed. So if you hinder the right of the people to keep and bear arms, that constitutes an infringement. And the last person I want to talk about, it's a new name I want to introduce, is Thomas Sheridan. Thomas Sheridan was an 18th century actor. He was a playwright. He was an educator. He was really a multi-hyphenate, a very fascinating character, but he also was a lexicographer. Now, Thomas Sheridan is used by the U.S. Supreme Court in the Heller case to again define multiple words. Specifically, Thomas Sheridan's dictionary is used to define the word bear to show it's consistent with Samuel Johnson's definition as well as Noah Webster's definition. Specifically, Thomas Sheridan defines to bear as to carry. That's specifically Thomas Sheridan's dictionary, called a General Dictionary of the English Language from 1780, is relied upon by the U.S. Supreme Court in Heller. So you have Samuel Johnson, you have Noah Webster, and you have Thomas Sheridan. And how does Thomas Sheridan define infringement or to infringe in the same dictionary that he used to define bear, which the Supreme Court relied upon? Well, Thomas Sheridan's complete dictionary of the English language, just like Webster and just like Johnson, defined hinder as to destroy, to violate, or, yes, indeed, to hinder. So here you have the key point. Whether you look at Thomas Sheridan, right, from 1780, whether you look at Samuel Johnson from 1773 or you look at Noah Webster from 1828, the three lexicographers the Supreme Court used in Heller to define the key terms of the Second Amendment, if you look at those three sources, those three historical dictionaries as to the meaning of infringement or to infringe, it means to hinder, which means that any minor restriction, any hindrance whatsoever of the right of the people to keep and bear arms constitutes an infringement and is and thus implicates or violates the text of the Second Amendment, and therefore the burden will shift at that point if a modern-day gun control law infringes upon, hinders, restricts the Second Amendment right of the people to keep and bear arms. The burden then shifts to the government to justify their modern-day gun control law with historical analogs, which is virtually impossible for them to do in almost all instances, if you're honest about it, because in 1791 there are virtually no or very, very few gun-related restrictions, virtually no gun control law in 1791, which means that almost all modern-day gun control laws, by and large, should fall by the wayside if you're being an honest broker about how the Bruin, which is really the Heller methodology as reinterpreted and reapplied in Bruin, if you apply those methodologies, we should win virtually every Second Amendment case out there as a general matter, but only time will tell if that actually plays out. We will see soon enough. All right, folks, hope you learned something here today at the Four Boxes Diner. Make sure you follow me on X at Four Boxes Diner. I got a lot more Second Amendment information coming out every day in addition to the videos. And again, don't forget to subscribe and resubscribe. Some people get knocked off the list. I appreciate it. We're trying to build up our subscriber numbers. I know we're pretty far behind everyone else in the Second Amendment community, but we're working hard to catch up. And again, we appreciate your time, and we'll see you again soon here at the Four Boxes Diner.
Orders up. Table 2A.